I had a client who was being sued. It was by a group of tenants. I think it was about 10 or 11 tenants, all claiming habitability issues. And that one went to trial. At the end of the day, the jury found the owner liable for, it was about $100,000. Pursuant to the local ordinance here, that was tripled, so about $300,000, which is not an uncommon settlement these days to resolve these claims. But here's the problem. The owner was on the hook for attorney's fees. Even though the total liability as determined by the jury was $100,000, the attorney's fees were $1.2 million. So just to emphasize the point that these lawsuits are oftentimes attorney fees driven. He's looking to get paid. Actual judgment for that amount against the landlord. And sometimes the award may exceed the policy limits of the insurance. Sometimes, like I mentioned earlier, the insurance may not cover a claim or a lawsuit. You know, if they have the wrong policy in place, and I meet with them and I cringe because I know this is going to be very expensive. It's oftentimes for a mom and pop owner. So Brad, if that was to happen and the owner at that point was not asset protected, they owned individually in their trust, is there anything that can be done after the fact? Is there anything that you can do once that lawsuit has been filed?
Yeah. Okay. So this is one of those real sensitive and gray areas, and so this is where people want to seek professional advice. Okay. This is where you don't do internet research, and many times I spend more times counseling my clients to try to get them to unlearn all that they've learned from what they see on the internet. So the idea is just because you can't do anything, it just means that anything that you do is going to get it's going to be scrutinized, right? A much higher level of scrutiny. So the clients are able, post-complaint, not post-judgment, post-complaint, they are able to still do some asset protection. It's just that you have to be very careful because everything that you do, entity formation, property transfers, are going to be highly, highly scrutinized and certainly attacked by plaintiff's counsel. But you also have to know, Stephen, you know this, and you said it earlier, not only is litigation expensive, it also takes a long time, right? Yeah. So it's timely. And so you have to remember that if litigation goes on for a couple of years, there are certain things that people do in the normal course and scope of their business activities, the normal course and scope of their family activities that people do. I mean, such as, you can create an estate plan. I mean, you can buy an insurance policy. You can buy another piece of property. You may want to take a home equity line so you can finance the purchase of another property. You can contribute to your 401k plan. I mean, there are things that are done completely outside of the area of trying to hide your assets from creditors after the fact. So that's where it's important that you have that proper balance in working with a proper professional, is because if anything you do post-complaint is going to be scrutinized, you better have an answer for what you're doing other than, I'm doing this for the sole and exclusive purpose of trying to avoid paying my creditor's claim. So I guess that's my answer. And there's a real fine balance. And that's one of the areas where working with an experienced professional helps, because people can get in trouble here, right? I mean, not only the clients can get in trouble, but the lawyers can also get in trouble if you're doing things that are unethical, right? But also just remember, the wheels of justice turn slowly, and life goes on. It just means that like I said, sometimes hindsight, they look back at you. You just better have a good answer for them.
All right. So it sounds like the important lesson is be proactive. And
absolutely. Going back to that insurance policy, right? I know that every time I bought a piece of property and I had my property insurance people come out, they came out with cameras. They took a picture of the crack in the driveway. They took a picture of this crack and this stairwell, and they took pictures because what they were saying is that, you're covered, but I'm actually carving out these specific exclusions because these are pre-existing conditions. So you can look at a lawsuit as a pre-existing condition, and you can look at the asset protection structures as the insurance policies. So you can have the insurance in place, But if you have a pre-existing condition, a lawsuit, it's going to be excluded. It's not going to work. It will certainly work for future issues, but it may not be as effective against the current problems because they're excluded. So that's why asset protection, just like anything else you do, needs to be proactive. It works great when it's proactive. There's a lot of room for problems and issues if you're doing it reactively as opposed to proactively.